रिकॉर्ड करें।
Good morning, sir. May I proceed on behalf of petitioner?
Proceed.
Thank you. Matter before the Honorable Federal Court of Indus Valley. Petitioner is People's Front for Democratic Rights versus Union of Indus Valley. The petitioner submit humble request as follows. Indus Land is the largest democracy in the world, which owes its origin to the parliamentary democracy of United Kingdom. Like United Kingdom, it observes the common law principles, but written constitution, federalism, multi-party system, sovereign state supremacy of constitution, strong judicial review and federalism are some of the distinct features of constitution of Indus Land. The Indus Land is the union of 28 states and South Land is one of the largest states of it. South Land exercises great influence on the political life of the country, and its every political action receives attention from the regional and national media. Third, the present case is, Your Honor, is an outcome of public interest litigation filed before this Honorable Court of Indus Land by an NGO named People's Front for Democratic Rights, challenging the grant of pardon to Mr. Sundar Das by the President of Iceland, Indus Land. PFDR, in brief, I will seek permission to use this word in place of full form. PFDR is an NGO with a mandate of creating awareness amongst the citizen about democratic rights. It has also filed many PIL in the Constitutional Court of the country for the protection of the democratic and civil rights of the people. Mr. Sundar Das was a businessman and former member of Legislative Assembly of South India. He was convicted by the Sessions Court for the murder of Rajat Singh and his family, comprising of his wife and two teenage daughters. The reason behind murder was the alleged political rivalry between Mr. Sundar Das and Mr. Rajat Singh. Mr. Rajat Singh was the leader of a local unit of labor union. Both had differences of opinion on some political issues, which were alleged to be the reason of murder. Mr. Sundar Das was convicted by the Sessions Court with death penalty. Against this decision, appeal was filed to the High Court of Southland and further a special petition in Federal Court. Both were unsuccessful. However, the President granted the pardon to Mr. Sundar Das. Your Honor, this point should be noted. However, the President granted the pardon to Mr. Sundar Das on the ground that his post-conviction report by jail authorities affirmed his good behavior in jail. So this point, Your Honor, should be Noted. The petitioner on the admissibility of this petition submits that as the whole family of Mr. Rajat Singh was killed and no one remained in the family of deceased to fight for justice. This petition is necessary to ensure justice for the deceased family and in the interest of the society. The sting operation conducted by media, the spokesperson of the President's office revealed that Minister of Sports had a keen interest in getting the pardon sanctioned for Sundar Das. There was discussion in national media that the President was not willing to grant pardon but succumbed to advice of Council of Ministers. It is humbly requested that instead of merit, the pardon was granted due to political affiliation. Regarding the bindingness of the advice of Council of Ministers, the President is independent of the advice of the Council of Ministers, and the Constitution of Indus Land does not provide such limitation. It is submitted humbly that the President's power to grant the pardon is to take care of their own people as the head of the executive and is expected to be exercised in a just, reasonable and impartial manner. This did not happen, Your Honor, in the present case. The pardoning order has been granted on extraneous or wholly irrelevant considerations. The petitioner underlined respectfully that mere good behavior of Mr. Sundar Das in jail cannot be a sufficient ground for grant of pardon, as he was alleged to be enrolled in many other criminal cases. The petitioner humbly submits that though there is a presumption of exercise of public power by the head of the state in a responsible way, in case of its rebuttal, the federal court can't remain silent. The lack of meaningful checks on the prerogative of pardon will result in its frequent abuse. At common law, a pardon was an act of mercy whereby the king could forgive any offense. This power was absolute, unfettered, and not subject to any judicial review. It is further submitted humbly that just like its origin, the pardoning power of President in the Constitution of Indus Land is immune from judicial review. It is submitted that such pardon is for political gain rather than justice. It is biased or arbitrary. Therefore, kindly allow this petition as it will defeat the spirit of Constitution. That's all for my plea for admission this year.
मैं क्वेश्चन में शुरू करें और प्रोसीडिंग
So, according to Senior Defense Counsel, that ground are not relevant for admissible of petition because President is the executive head of country and first citizen of country. So don't any asking a questions to about the constitutions. any decisions to taken by the President of India, some discretionary power and according to constitutions and Council of Ministry, and advice of by the Supreme Court, Chief Justice and others. And the Senior Defense Council are saying are not relevant as good behavior for party. So, any person to punish the death penalty and take a jail for and behavior in a jail is a behavior is most important of accused, because jail is a very important class of sociology. According to jail, very easy to understand of society by the jail, because jail diary is a mirror of particular area, because it is divided into the crime and different accused to under a different crime. So behavior is the most important, and jail superintendent opinion also most important. So burden is reasonable, sir. And second thing is, sir, page number first, sir, para number 3, first line. Mr. Sundar Das was businessman and former member of Legislative Assembly of South. Accept. Sundar Das, suppose, are not member of Legislative Assembly to take a stand by people of Front Democratic Line of NGO. No, sir. Because that petition is completely attention seeker and publicity stands, sir. And doubtable questions, sir, of President of India. Because of Indian President are not functional according to constitutions. Because executive work is doing by the Minister of Council. So, President is not a rubber stamp, sir. Anybody else put down the hands and question to the President of India. And this Sundar Das was second last line, sir. Sundar Das was convicted by the Session Court with death punishment. It's capital punishment. But beyond the petitions of Session Court and don't listen to appeal of High Court. Don't any direct evidence in the case, sir, for capital punishment, Mr. Sundar Das. Just only circumstances evidences of chain are not completed. So, so second point is basically is accepted to pardon. But these cases are not a problem of pardon of given to the Sundar Das by the President of India. Problem is that interpretations of pardon case is exactly right now. And so that petition are not relevant because most of the motive are fully attention seeker. Sir, page number 3, second box. Basically, these petitions are asking up 4 questions of the government and President of India. So page number 3 of the main copy is matter is put before the Federal Court of 4 considerations. The Honorable Court will hear the argument of both the parties on following important issues. These are 4 questions are totally interpreted questions. power of pardon. So first is executive power exercised by the President in granting pardon to Mr. Sundar Das as per the spirit of pardon. And handwritten copies of recent number sir, fourth sir. Recently, that type of issue in USA. Recently, the US President Joe Biden issued the full and unconditional pardon for his son Hunter Biden, who faced sentence for illegally honored and care bill using the drugs and for the tax related offense. Because of President of USA are functional executive head of the US, and that perceptions is different in India because post of president in India. Everyone to see the president of India as a rubber stamp. So it's not a rubber stamp. Multiple power given by the constitution to the president of India. Executive power, discretionary power, and legislative power, and military power, etc. And not a functional. So, sir, questionable post is president of India. No, sir. Everyone question down to for sir, that reason is also minimize the pardon decisions are not subsequently time to time seen in our society because of precedent is a nothing in India. Everyone understands that and is thinking to already accepted that in mind of to the precedent. So, pardon power under Article 72 of Indian Constitution given the President of India the power to grant pardon, remand or commutate sentence, grant receipt and a remission of punishment of perceptions that the sentence of any persons convict of any offences case there. The punishment is by the martial court, sir, and sentence involved capital punishment. So death sentence. According to Article 72, sir, direct clearly say that power of president for on a capital for the capital punishment, sir. And the convict is for the offence under union law, sir. The significance of pardon, page number 4, sir. This power ensures that the president can remedy potential judicial error, or that case, sir, completely error because lack of evidences, direct evidences are not presented, only circumstantial evidences or chain are not completed in this case. Just only victims are highly popular and former member of legislative assembly. Or just one questionable doubt, sir, is the rival, politically rivals, or nothing is that in case. And, sir, the principle was the upheld by the Supreme Court of the India is landmark case such as Maruram versus Union of India, 1980. The Supreme Court held that the power to grant pardon must be exercised fairly, sir, reasonable and without arbitrage, ensuring justice and balance, sir. Justice and balance, sir, is most important thing of the pardon of power. I'm complete to And second case is sir, Kehar Singh versus Union of India, 1988 sir. The Supreme Court held that the President pardoning power is the independent of the judiciary sir. But it can be revoked to ensure perceived fairness. The review is focused on the address to constitutional principles and proceeding requirement, not as a permit to the decisions. Executive power appeal exclusively to federal crimes and does not extend to state level offense or impeachment cases. Second thing, sir, according to Article 53 of Indian Constitution, executive power of the Union held by the President of India. Executive power of Union shall be vast in the President and shall be exercised by him is either direct or through officers subordinate to him in ordinance with this constitution. Whether judicial review of presidential power of pardon by the Supreme Court, Federal Court of India. In the present case, violate the doctrine of separation of powers according to defense lawyers. But it is not true, sir, because power of separations is clearly defined in Indian Constitution under Article 50. The separation of power is the divergence of the legislative, executive and judiciary functions of government. Under Articles 50, it says that the state shall be taken a step of separate by the judiciary from the executive. Sir, parliamentary rule book is different. Presidential rule book to different field doing by the work by the president to the sub to the country is a different thing. So these are ruling book are balancing created in the constitutions and executive. Because constitutions is a key law, sir. Is single words is vast meaning. Because everything is not considered in Indian constitution. Basically, largest constitutions of the world. So everything is not considered in that. So it's different union of law. Very smoothly correlate to the constitutions of India. And the constitutional dramatic proceed the concentrations of exclusive power by any branch of the government. Indian constitutions lay down the structure and define and determine the rule and functions of every organs of the state and establish norms for their interrelationship and check and balance. Basically, I am saying that so that pardon's decisions are not wrong, sir, because to take a pardon of decisions by the President of India is completely according to constitutions and different union of law, not violations to any things and not inflation of political issues, because that type of case are not a first, sir. This same case, sir, is very famous, Mr. Rajiv Gandhi assassination, sir. And recently, Indian President are granted the pardons is man accused in the Rajiv Gandhi case. Why are asking the questions of precedent decisions to the pardon by the defense lawyer? Just a attention seeker and to the publicity stints. This one nothing admissible. Thank you.
Sir, as my I have placed the ground of admission for PIL and my colleague for defense has described and submitted his reply on the issues made by the court. It means my honorable court has admitted the PIL. If admitted, then kindly permit me to proceed. Because all the issues are framed after the admission is granted by the honorable. And if granted, as yes. So my objection is the ground of good behavior in jail is not reasonable ground for pardon. One who committed heinous crime and convicted by session court and upheld by the High Court and Supreme Court also, and on the basis of a political affiliation, he succeed to get pardon by the president. So this is not fair, and as per the issue, can it be challenged in the apex court? Yes. The power of pardon can be challenged in court of India, but only in a limited circumstances. Circumstances are if it is deemed to be irrational, discriminatory or malevolent. Second one, if it is deemed to be arbitrary or unreasonable. So, Your Honor, this falls under this category. To rely on the report of the superintendent of jail, president is pardoning such criminal. Third one is if it is deemed to have been exercised on irrelevant considerations. President of India is empowered to grant pardons, no doubt, but which type of pardon he may reprieves, respites or remissions of the punishment and suspend, remits or commutes sentences. President cannot exercise this power independently. And purpose of Article 32, Your Honor, is to provide human touch to the judicial process. If the human touch is not exercised properly, as the present case reveals, the very purpose of mercy provision is defeated. Spirit of Constitution is as mentioned in the preamble of the Constitution and the constitutional remedy in Article 32 as a fundamental right. And it clearly shows that to secure the citizens' justice, as if social justice, either economical or political. So this case is clear-cut politically affiliated matter, and it has been revealed in the sting operation, which is legal process under constitution in article 51A. It confirms that sting operation can be done. President's spokesperson has revealed that some minister is keenly interested and he tried to get consensus of all the council of ministers, and this pardon was made. As the constitutional debate on Article 72, the judicial review and nature of the power transfer, currency of the accountability and scope of pardoning was discussed during that time. So the president has the power to grant pardon, but not arbitrarily or in a biased manner. So it is kindly requested to kindly review this decision. Thank you.
So, question is that political implication. That is one-sided argument is political implication is not true, sir. Because proceeding of burden, any accused persons to send the applications for pardon for President of India. After then, President to take a stand, some different things such as jail diary and case file to related case and conviction file, and after then they read and send to the parliament. Then common opinions to take a file and read by the president of the victim. After then send to the file of the parliament related to the committee of pardons of parliament. Its brief discussions and common opinion to take by the parliament and send to the again president. And president to order the spokespersons that news are published, convicted yes or not to the particular accused. Question is that, sir, my accused Sundar Das are former member of Legislative Assembly. Same thing, these are not member of Legislative Assembly, just a simple people to take a stand by the People's Friend Democratic Right NGO, not so. Because that time subject are not public opinion, they are personal benefits to take that case, sir. Because second opponent is a former MLA and sympathy to Rajan Singh and Rajan Singh family is not a good, but that's I am saying that they are also political leaders of labor unions, or both are political rivals. In India, political issue is explorer material. Society hand to hand takes, and a small issue I don't understand very large big issue and voice of that issue to take in a parliament, sir, in that time, sir. And multiple organizations, especially according to Indian government, Human Rights Commission, sir. Human Rights Commission not take a stand in that case. Because Article 722 are clearly say that President of India grant to the pardon of particular accused. In fact, death punishments also, sir. Discussion is finished. That matter is not a grant to the pardon or not. Matter is that interpretation of pardon, power of pardon of president. My defense lawyer are not accepted that point. They are come to again and again ground of petitions. They are already written up 4 questions asking the government and the Honorable Supreme Court of India. Why not discussing in that question, sir? Because, and very good thing is to my defense senior defense lawyer and prosecution lawyer, Article 32, Constitutional remedies. Constitutional remedies are violations of fundamental rights. Don't have any violations of to another persons by this grant to the pardon. Because President of India is a protector of the Indian Constitution. Any protector of to anyone are not violation to any right of any person. So these are not a constitutional remedies matter. And judicial review is the right of a prosecution's lawyer. And they accepted that because according to under Article 13, they are power to the judicial review to take a stand and demand for the Honorable Supreme Court. But not that grant to the pardons or not. Debate on the interpretations power of pardon of President of India. Point is that, sir. Thank you, sir. And so, judicial review and judicial activism start in India 1980. These concepts are Western countries, but to take a stand by the Honorable Supreme Court for the public interest issues, and at a time judicial activisms are completely attention seeker instrument to the educated and active member of the society. Some political influences and sticker on the pasted on a forehead. We are social services, but it's not that, sir. They are completely political propaganda because disturbance of the working of government. And time to time take a different thing. Questions of Indian constitutions is good or not, etc. All that questions. So judicial activism start for good things, not a political benefit. Take a political benefit. And senior prosecutions lawyer are already accepted that they are empowered and awareness for democratic right, and to time take a stand, and multiple PLI are registered by that by the prosecution. Basically, that question is not good or bad. Question is that, sir, their PLI are number of count increased by the prosecution's lawyer. There are some political benefits. Thank you.
As my colleague for defense objected that this PIL has been filed on the basis to get publicity only. But I object that it is not for publicity, but for a person whose family has been brutally assassinated by someone, and to ensure justice for deceased family where no one remained to fight, this friend has decided to fight against him. Second one, the pardoning power of the president. As my colleague is saying that this is only the interpretation, interferences on the government process, the government work. So I would like to clear two Supreme Court rulings before Honorable Court. That is, first is Maruram versus Union of India, 1980. Your Honor, this is mentioned. Here. This is a milestone in Article 70. Before 1980, it was deemed that as per the United Kingdom, emperor cannot do wrong, and he has supreme power to pardon or anything, whatever he wants. But in this case, when apex court ruled that president must act on the advice of the Council of Ministers. So this was very landmark judgment. And second judgment is Kehar Singh versus Union of India in 1989. This is the very popular case for assassination of Mrs. Indira Gandhi, and pardoning was requested by all the Sikh community, that he served very sincerely to Prime Minister's house. But at that time, government of Congress was there, all the ministers was not in favor to give pardon, hence pardoning was not allowed. But court decided that Supreme Court ruled that the president's decision to grant or deny clemency is not open to challenge on merits. So on merits, it cannot be challenged. But criticism of pardoning is still continued on the basis of political consideration. Critics say the pardoning power is often used for political gain rather than justice. And second one, vice and arbitrariness. Critics say the pardoning power is sometimes used in a way that is biased or arbitrary. And third, lack of transparency. Critics say the pardoning power is not transparent enough. And in the present case, the same scenario has arisen. The basis of pardoning is taken only a report of Superintendent of Police that after committing crime, Mr. Sundar Das was in jail for 3 years, and Superintendent reported that he served in jail in a very good manner. So it is the ground to pardon. So this is totally biased. And second, as in my reply, this was revealed in sting operations. That President's spokesperson has narrated that the one sports minister was keenly interested, and he managed to all the council of ministers. So this is matter of consideration, and it may kindly requested to review the decision of the president.
क्योंकि और कुछ रेस्टोरेंट और कुछ टेस्ट रखना चाहता है अपना पक्ष।
Yes. Kehar Singh versus Union of India 1988 sir case. Indira Gandhi assassination sir. Government not a particular party sir. Yes, accepted. Government make a particular party, but not governed by particular party. They name to government of India. Kehar Singh versus Union of India is different case is that because assassination of Prime Minister of those time. Rajat Singh highly sympathy government and also me, but not that post, and they are not present any issue. Pardon is not only one ground ki good behavior of report by the Supreme Judge Supreme Court. Not so. Pardons is very broad processings to grant the pardon. I am explaining it. And Kehar Singh case, very good thing, verdicts of the Honorable Supreme Court, that the precedent proceeding power is independent of judiciary. That question is missed that by the Honorable prosecution, but it can be reviewed to ensure the proceeding fairness. Clearly mentions of fairness. The review focus and address the constitutional principles. India is not a India is a democratic country, not a that Raj science. Defense prosecution's lawyer are quote the examples of British Rajshahi. Sir, totally different. because British Constitution is not written. Indian Constitution is written and largest constitutions also. And every point is very brief discussions and by the constitutional assemblies and those time made by the during constitutions. And second thing is misread by the prosecutions Maruram versus Union of India 1980. Supreme Court clearly said that held that the power to grant pardons must be exercised fairly. Again, fair, reasonable, and without arbitraries, ensuring justice and balance, and check and balance of power concept. I am already explaining it. And recently, so page number 5, question number 2, according to petition, judicial review of presidential power to proceeding by the federal court in the present case violated the doctrine of separation of powers. Recently, Vice President of India has wrinkled the debate about the doctrine of separation of power by the citing the Supreme Court landmarks. 1973 Keswanand Bharati case, which ruled that Parliament has authority to amend the constitutions but not its basic structures. That petitions again and again put down the questions of basic structure of the constitutions, and separations of power is the divisions of the legislative, executive and judiciary functions of the government under Articles 50 say that the states shall that take the step of separations of judiciary from the executive, the constitutional democratic proceedings of the constructions of the exercise power of the branch of the constitution government. The Indian constitutions lay down the structures and define the derivative of role and functions every organs of the state and stabilize norms from the interrelationship and check and balance also. And judiciary beings advised to check and balance, the Supreme Court had that the 99 constitutional amendments, which provide for the stabilize of the National Judicial Appointment Commission as the ultra versus. The National Judicial Appointment Commissions guaranteed to independent of the systems from inappropriate, politicized and strengthen the quality of appointment. That sir has, which means saying that President of India and Honorable Supreme Court are already accepted. That type political influence and any other things to disturbance the constitutional basic structures are not admissible, sir. Constitution's lawyer saying that same statement, sir. And judiciary activisms, I am again explaining it, sir. In many recent judgments, the Supreme Court has become hyperactivist, sir, in making judgments that are demean a law and rules, sir. This transgress the domain of the legislature and executive. So, cases Indra Saini versus Union of India 1992 saw rule define the rule of law by the Supreme Court of India, part of the basic structure of constitutions. And VR Bommai versus Union of India 1994 saw federalism, socialism. Constitution's lawyer started by the PLI in that statement, sir. Federalism, socialism, sovereignty, etc., etc. at all. These words are explaining at a preamble of the Indian Constitution. So. And B.R. Bowie versus Union of India 1994 are explaining again in that statements of federalism, socialism, democratic, united and integrity of the nation and social justice bear entrenched as the basic structure of the Constitution. So. And no, the Supreme Court judicial review of the presidential power does not serve. Violated of doctrine of separation of power because the constitutions of India allow the judicial review. That is the right of constitutions lawyers to take the stand for a judicial review. But don't any doubt of precedent power for grant to the order. Their tastes are clearly stated, sir. The constitutions of India does not explicitly mentions judicial review, but it not impact under articles 13, 32, 136, 130, 42 and 100 or 226. And third questions of petitions of answer to take a stand in that questions because the prosecution's lawyers are again and again political inflations and jail diary also good behavior of accused. They are not discussed about that in that question. So where the power of the president to the grant pardons to independent of advice of the Minister of Council of Ministers. Is recently, sir. That statement is recently. The claim made by the center that the president had executive powers to decide whether to the pardons Rajiv Gandhi assassination. Nalli cases. I am talking about Nalli cases. Nalli is released in a recent. Convicted is draw the criticisms from the Supreme Court before the result is that case for judgment. Nalli is not a normal accused, sir. They are involved in conspiracy of assassinations of the former Prime Minister of India, late Mr. Rajiv Gandhi, sir. That NGO are I am asking why not take a stand in that case? Why I am interested only in that case, sir? I am questioning that prosecution, sir. Only that case, sir. And Dhananjay Chatterjee versus State of West Bengal in 1994, sir. Detailed proceedings, sir. Proceed Rashtrapati Bhavan. They are Speaker of Rashtrapati Bhavan. So Rashtrapati Bhavan's forward the Mehmeti Press, the Home Ministry is sequence of the Cabinet Advisor. The Ministry of the Turn is forward this to convey state government is basis on the reply and formulated and advice on the behalf of the Minister of Council. Grant to the pardons is not a particular decision of the President of India. Minister of Council are also involved in it.
Incoming call from Reshu Park.
The President has no option but to take accept it, sir. Not that a President is while proceeding Sundar Das his political influences and hence disagreed is very covenant of constitutionalism alleged by the petitioners. And I have no explanations because multiple cases and Indian constitutions are to take a stand of on the behalf. Just only explainer it, sir. So take something else, asking us something else. I am ready to answer it, sir. Mr. Prosecution's question, sir. Thank you, sir.
Sir, to conclude the as I mentioned on page number 4, para 7, there was discussion in national media that the president was not willing to grant pardon but succumbed to advice of Council of Ministers. And second, instead of merit, the pardon was granted due to political affiliation, as I have already mentioned. Regarding the bindingness of the advice of Council of Ministers, the President is independent of the advice of the Council of Ministers, and the Constitution of Indus Land does not provide such limitation. And above all, it is a presumption that to exercise of public power by the head of the Constitution is in a responsible manner. In this case, if its rebuttal, the federal court cannot remain silent. So the same is requested. The lack of meaningful checks on the prerogative of pardon will result in its frequent abuse. As per the constitutional debate in Parliament before framing the Constitution, it was discussed on judicial review or Article 72, which is I would like to mention whether the Supreme Court can review the President's decision to grant pardon, particularly when concern of arbitrariness or malified intention are raised. So, as per the sting operation, such cases have revealed. So, it is requested to review this matter. Thank you.
Yes, I'm nothing in the argument of